Welcome to another episode of the Caroline Glick Show. As you know, last week we started Israel's trial for genocide at the International Court of Justice at The Hague. And last week we had 2 days of meetings, of hearings. The first was the South Africa's day to talk about why Israel is guilty of genocide. And the second day, Friday, was Thursday and Friday of last week, Israel gave its case of why this is completely insane. And now the judges are supposed to convene and make a decision whether or not to put out an interim order calling for a ceasefire or, all Jews to walk voluntarily into the Mediterranean Sea and put an end to it, or whatever it is that they want to put out. Anyway, there's a lot of stuff going on here, both on the level of what's actually going on in the courtroom in The Hague, but more importantly, what this spectacle, what this Kangaroo courtroom means for the future of warfare, for the future of lawfare, which is using the language and sort of the theater of law to advance political goals, military goals. And I wanted to talk about both what's happening in The Hague and also, more importantly, the broader picture of what we're seeing with my friend and my longtime colleague and frequent visitor on the Caroline Glick Show, Professor Avi Bell from Ilan University's law school and also University of San Diego Law School. So I'm glad to be able to catch him in the studio. So first of all, welcome to the show, Avi, Professor Avi Bell. Great to have you in the studio, I think for the first time.
Very first time. Thanks for having me.
Oh, it's terrific. So first of all, let's talk a second about what all of these, what an interim order is, and just so that we understand what's happening. South Africa, which is aligned with Hamas and with Iran, put out this preposterous claim against Israel that Israel is committing genocide. I talked about it on In Focus last week. What can we expect from what's happening at The Hague?
So it's like a lot of international institutions. There's a gap between the rhetoric and the reality.
Okay.
So what people say is it's the premier international law court. And in a way it is. And when it puts out judgments, then in theory, states are supposed to listen. In reality, states don't. It's completely toothless. The reason to bring a case to the ICJ is not because the ICJ can do anything, because it can't. It's primarily for two reasons. Number one is it's a way to present a narrative. And this is a way for Hamas to put out the narrative that they're the victims of Jew evil, instead of being the perpetrators of evil. And number
against
two,
Jews.
Right, perpetrators of evil against the Jews, right? And the other thing that the ICJ can do is it can provide cover for actions elsewhere. So let's say I want to bring an action in Canada, let's say to block import of something or another, right? Some Israeli product. So I'll go to whatever board it is that's in charge of issuing the licenses, and I'll say, look, the ICJ has just issued a decision saying that the Jewish state is really, really awful and Nazi-like. You have to ban import of Israeli wine or something like that. And that's the way it's intended to work for South Africa. Narrative and cover, right? The actual legal process itself, in that sense, is totally irrelevant because nothing that comes out of it is meaningful in and of itself. Now, the way it works is in any case before the ICJ, you have to prove two things, right? You have to prove the court has jurisdiction. It has jurisdiction over very, very, very few things. So that's generally a whole independent procedure. And then you have to prove that you're actually entitled to whatever legal order you want to get. And that's generally the way the ICJ cases go. What South Africa did was it did something smart from their point of view, from Hamas's point of view, which is they said, before we even get to any of that stuff, before we get to jurisdiction, the merits, give us an interim order ordering Israel to stop doing X, Y, and Z. And there's two benefits to this from their point of view. One of maybe the major benefit is that it's quick. The other one is that the standards are very, very different. The court is really eager to prove its relevance. And so it keeps making up new doctrines by which it can do things, even though fewer and fewer states in the world actually are interested in being part of the ICJ. And so the standard that they have for an interim order is that the claim has to be, quote, plausible. Okay? It doesn't have to be convincing. It certainly doesn't have to be true. It doesn't have to be anything in the court's jurisdiction. It just has to be plausible. So here they are. They can get up and make these outrageous charges, complete lies. And not only have they shifted the burden to Israel, where Israel has to prove its innocence, it's that even proving Israel's innocence is not good enough. What Israel has to prove is that everything that they've said is implausible. Okay, which the South African lies are made up to be in part irrefutable, right? Because the main part of their lie is about what's in the heads of Israeli military planners and Israeli elected officials, and go prove that they have something different in their heads than the thoughts that South Africa is ascribing to them. So anybody who's inclined to be convinced that Jews are evil, and the ICJ is so inclined. The ICJ ruled 19 years ago that Israel has no right to self-defense when attacked by Palestinian terrorists. It's certainly willing to do that again. And so to anybody who Jewish evil sounds like a reasonable baseline, a plausible baseline, interim order, here we go. And
so wait, okay, so I think that it's not an unfair assumption to assume that they're going to issue an interim order against Israel that says something. And then there are two ways of looking at it. And so I want to just lay them both out, or two ways that I can see that we can look at it. I want to lay them both out. And if there's a third that's more important than the two that I see, then you can mention that as well. But the two that I see are, one, I understand that the UN Security Council can convene and issue some sort of a resolution requiring the implementation of the order. And then the other thing, I guess, would be the continued use of that interim order as a basis for expanding a financial and other boycott against Israel internationally, like the example that you gave of a boycott of Israeli products in Canada or anywhere else, so that there would be two vectors. One would be the political warfare, which this is essentially an aspect of, and the other one would actually be a binding international resolution in the UN Security Council against Israel that would say something or another that then the U.S. or Britain or somebody would have to veto in order not to put it into force. Am I correct about those two vectors?
I would say not entirely.
Okay. So explain.
So what's the connection, let's say, between the ICJ and the Security Council of the UN? Nothing. Security Council can issue sanctions against any state where it recognizes a threat to
international security.
Right, to international peace and security. And it's subject to the usual limitations on Security Council action, which means it has to not be vetoed by one of the 5 permanent members. And right now, the situation is that the Biden administration is not going to politically be able to support sanctions against Israel. Will that change if the ICJ issues an interim order? I can't think of any reason why it would change. Right? I think that the political situation is the same. How about in domestic courts? Will something change in Strasbourg, or it will change in Canada? Will it change in the UK, where the BDS advocates will say, now we've got a judgment. And I think that it will change, but not that much. The interim order, the things that South Africa is asking for are not designed for BDS. They're designed for trying to force or supplement U.S. pressure to allow Hamas to win. And it really is up to Israeli leaders to have the good sense to ignore any interim order. If Israel ignores an interim order, I think that there are no consequences. The consequences are if Israeli leaders are foolish enough to take it seriously.
Well, right now they seem to be taking it seriously.
Well, I don't taking it seriously. We have to understand this is part of a broader diplomatic and lawfare campaign against Israel, and it's important to take that seriously. But part of it is recognizing what the threat is and what can be done to Israel and what we have to worry about.
Okay, so let's just go back again, define again the threat as succinctly as you can. The threat is what?
It's a narrative threat, right? They're putting together a narrative of Jewish evil that they will be using in diplomacy and in public relations in the democratic states in the world to try to turn the public against Israel or to reinforce the existing prejudice against the Jewish state in the Western world. And the other thing is to provide fig leaves for mostly bureaucratic action against Israel, again, in the West. Now, the interim order, when it comes out, is pretty small in the big picture. Even right now, as we're speaking, okay, we're talking about this ICJ case that South Africa launched. Now, as it happens, there's another ICJ case against Israel right now. Okay? It's for an advisory opinion. And the ICJ was asked by the General Assembly to issue a ruling on the legal consequences of Israel's illegal occupation of the West Bank and the Gaza Strip and East Jerusalem and Golan Heights. And the ICJ is going to oblige, and later this year, or early next year, the ICJ is going to issue an opinion in which it does call for BDS, right? It does find Israel guilty of illegally occupying all these territories and so on and so forth. And that is a much more useful fig leaf for the BDS advocates than anything that will come out in the interim order. The idea of the interim order is to foil Israeli military operations, right? And we just have to be smart enough to pay no attention to that noise and to keep doing what we're doing. And there is something I do have to mention. Now, South Africa is not the first state to try to play this game. So about a year and a half ago, Ukraine went to the ICJ to ask for interim measures against Russia. And it had a problem similar to that of South Africa, which was that it had no good claims over which the court had jurisdiction. Right? Now, Ukraine had a lot better claims than South Africa has against Israel, because in this case, Israel's acting according to the law, doing even more than it has to, than the law requires. Whereas Russia...
And we were invaded.
Whereas Russia clearly violated the law, and Russia clearly invaded, and illegally so.
Right.
But the ICJ is not a court of general jurisdiction. There are very few treaties that actually give the ICJ jurisdiction. And so the Ukrainians made up this genocide claim. And here was their genocide claim. They said, the Russians claim that we Ukrainians are committing genocide, and the Russians are claiming this in order to buttress their argument that they're permitted to take military action against us. Therefore, we have a dispute with Russia about the Genocide Convention, and you, ICJ, should issue an interim order against Russia on the basis of this dispute, which you have jurisdiction over, telling them to stop the fighting and do all sorts of other things. And the ICJ made an accelerated schedule, just like they did in this case, to hear the case in order to decide on interim measures. In the Ukrainian case, the legal argument was preposterous. The Russians were not claiming any right to invade on the basis of the Genocide Convention. They were claiming other reasons why they were invaded. Primarily, they were saying they're invading at the behest
of the ethnic Russians, and
right, who were asking for their assistance. So the Russians said this has nothing to do with the Genocide Convention. On this, the Russians were right. The court didn't care because the court was interested in establishing its authority, and so the court ruled that it had jurisdiction enough to issue an interim order, and then it issued an interim order that had everything in it, including an order for the Russians to stop fighting. Everything the Ukrainians asked for. And they issued the order, And then Russia said, thank you very much. Russia never even bothered to show up for the hearing. And then Russia continued doing what it's doing. Now,
see, that's the thing. That was another aspect to it, of the internal debate in Israel, which was, why did we bother to send a legal team to argue against this obscene allegation against Israel, and whether that was a correct move or not? I know in 2004 we did not send a legal team to argue, also citing their lack of jurisdiction, and this decision was apparently made under duress by the United States, that was, among other things, holding its Security Council veto over Israel's head and saying that you have to go and you have to be part of this thing. And what's also interesting, apropos, maybe I shouldn't talk about it now, but I just noticed this morning, the Hamas, I think, was demanding, and the Turkish were demanding, that Egypt join the South African claim against Israel on the basis of what they know about the humanitarian relief that Israel is or isn't allowing in. And so, apropos, undermining Israel's war aims. So Egypt doesn't want Israel to take over the Palestinian side of the international border, because allegedly we'll discover just how much they've facilitated Hamas's war machine once we're in charge there and seize control over the border. And so now Egypt this morning, according to one of the Arab news reports, is planning on claiming that Israel is committing genocide. So, I mean, it is definitely, as you said, an effort to undermine Israel's war effort on the one hand, and on the other hand, you see that the Biden administration is allegedly actually using this case against Israel to coerce Israel into making concessions.
Yeah, I listen, I don't know all the politics behind the scenes, and I'm reluctant to make definitive comments about something I don't have better evidence about. I can tell you,
true law professor, I must add. Yes.
I can say this, that whether Israel should participate or not, or how it should be participating, this all has to be subordinated to the larger question of what's Israel's strategy here, right? What is Israel hoping to accomplish, and what's the best way to do it? And so it seems to me that what Israel ought to be trying to do is the reverse of the things that the Hamas and its allies are trying to get out of this. So if they're trying to sell a narrative, we should be doing the same thing.
Well, they seemed to do that on Friday when they talked about the acts.
So somewhat. I think that in that sense, Israel made the right decision to participate. The way to think about this is it's a big platform, and if we don't go, it's still going to be used against Israel. They're going to get to tell their narrative. Maybe it's not a bad idea to use it not to speak to the court, but to speak to the world. Right? Through the court. Again, you have to think of courts as theater. Think Trump, okay? And this is the way he deals with all of his cases. He's not only thinking about who's going to win or lose, and in fact, the outcome is pretty close to certain. It's more a question of using the courts and the attention that they draw in order to sell a narrative. So that's one of the things. And I think in that sense, Israel has, at least it seems to me, made, if not definitively the right choice, a defensible choice, one that it seems to me there's a good possibility we've done the best we can to sell our narrative in this circumstance. The other thing that we can do, and we have to think about, is they're trying to use this as a fig leaf. What we have to be trying to do is to prevent that as much as possible. And how do we prevent that as much as possible? I think that we have to weaken those institutions that are open to being exploited like this, like the ICJ. The ICJ is a terrible institution for us because it's one that's not based on international law, which we abide by. It's based on international politics, where we
lose every time.
We're by definition set up to lose, right? And so any one of these institutions that runs according to the logic of international politics is one that we need to delegitimize, to weaken in every way possible. And the other thing in the ICJ is it's a big player in shaping the rhetoric of international law. And here there's a big advantage to participating, because if you participate in a case that's a interstate dispute like this one is, you have a right, the state, any state that's involved in it has the right to appoint an ad hoc judge, to send a judge that is at the very least going to be able to give one judge's opinion that's going to appear in the case reporter, that gives a different view of international law and gives an international law that is closer to the real thing and less to the international politics one.
Israel sent Aaron Barak to represent it as to be its ad hoc judge.
Which I think is a mistake, because if you read Barak's judgments for the Israeli Supreme Court, his understanding of international law seems to be closer to the international politics version than the actual international law version.
Right.
And he doesn't seem to me to understand his role in that way. The optimal ad hoc judge for Israel, for a state that which is always under this international apartheid campaign of, there's going to be one law for everybody else and one law for the Jews. The only way to fight that is to when you have an official platform like this, use it to put out an uncompromising understanding of the law. It's not, because you're not going to win. The idea is to move the Overton window. The idea is, right? The idea is to open up the space that we can have a legitimate discussion. And it doesn't seem to me that that's the kind of thing that he's interested in doing.
What's really interesting with him was, he's almost like a psychological study, right? Because he staked his reputation on this idea of international humanitarian law and on this kind of, almost like this Olympus where, you have these high priests of justice who understand better than everybody else what's right and what's wrong, but mostly because he sees himself as part of an international community of jurists, and that what happens in Israel is very significant to what happens everywhere else, and that Israel, through the High Court of Justice, can convince the nations of the world of the justice of our cause, and that the High Court of Justice, with its progressive judgments, is the best shield that Israel has against the international political lynch mob in places like the UN and the ICJ, so that he always saw his catering to this group of people as the basis for Israel's legitimacy in their eyes. And now he's there, and if he's willing to look, that he sees that was all not true, that they're not there because they have a certain concept of international law and they don't think that Israel's abiding by it, but rather that they're singling Israel out because they hate Israel. And so now he's sort of in a position where he's forced, if he were honest, if he's being honest with himself, to confront the fact that he's been telling a story that's just not true.
Yeah, look, what he's done in Israel is, in very broad strokes, as you say, the same kind of thing where the courts have seized for themselves powers they don't really have. If you look at the ICJ, almost all of its jurisprudence is aimed at coming up with crazy theories by which it has more jurisdiction than it actually has.
So they're just a big Aaron Barak Israeli Supreme Court.
The difference is the second part of this. Barak and the ICJ or the Israeli Supreme Court and the ICJ have a political / ideological agenda. And this gets us to the interesting thing. We've seen right now in the world with all the reaction to the Hamas atrocities, you have all these Jewish progressives who are all of a sudden feeling mugged. Here they were saying all these nice things, and it turns out their progressive friends are not interested in all those nice sentiments. They just don't like Jews.
Well, that was the thing, is that I said it when Douglas Murray was here on the show. I said, because he was quoting somebody's article saying that all of these Jewish progressives went to sleep on October 6th progressives and they woke up on conservatives. And I said, no, they went to sleep woke and they woke up Jewish.
Yes.
And that's really, and what I'm saying is that I'm wondering, is this going to happen to Aaron Barak as well?
So I mean, that's the real question, and I don't know. But if that does happen, it still doesn't seem to me that he's developed the right skill set over the years to be able to fulfill this mission. Because let's say he woke up on October 7th or October 8th and understood that his ideology, well, the people he thought were with him are not with him, right? That this progressive rhetoric is not about protecting rights. It's about having a double standard against the Jews. And so he understands that the international law has gone wrong. Right? Now, is he going to be able to convince his fellow judges there? Of course not. Yeah. Right? They didn't wake up any differently on October 8th. And you can see that the registrar of the court hurried up to allow the South Africans to play this trick. Right? There's no need to set hearings right away. They could have set the hearings a year from now, or right,
or never,
right? There's a case currently pending before the ICJ that the PLO brought against the United States
for opening up the embassy.
For opening up the embassy in Jerusalem. And where's it right now? It's just sitting there. There's no movement, right? The United States refused to cooperate. There's no movement. So the court didn't need to do this. Now he wakes up, and this is the situation. He discovers that at least when it comes to the international law rhetoric, all this progressive rhetoric, it's empty. It's meaningless. It's just a cover for anti-Semitism. Now, does that put him in a better place in order to put out a more realistic and sovereigntist and even balanced view of international law as a dissenter? I don't think so. I don't think that it equips him better to do that. I certainly don't think that it equips him better to go after the institution. I don't think that he's of the temperament to go after big courts. It's still something that doesn't sit with his worldview. He may understand something new about international law, progressive style, but that doesn't mean that he has a different view of the place of courts in this world. And he's not inclined in general to be able even to acknowledge that courts are political institutions. And so he's not inclined to say that I mean, what I would be saying,
right.
What I do say is what we're seeing is the International Court of Justice is on trial. It's not Israel that's on trial. But the ICJ has the opportunity to join.
Okay, so let's just finish the Aaron Barak chapter, because really what we wanted to switch to for the second half of this discussion is what you think, what is the strategic game going on here and how Israel should be playing it, which is exactly what you started talking about, but I just want to sort of clarify where we are in this discussion so people don't get lost. So you're saying essentially Israel may have chosen the single most inappropriate person to be the ad hoc judge on the courtroom because of his disposition and because of his worldview and because of his unwillingness to acknowledge that courts, like everything else, are, and particularly in this case, is a political
there's
body.
There's more reasons than that. I'll tell you as I tell you what I think we should have done. But Barak is certainly not the best person to make the argument that the court is illegitimate. It's not the kind of thing that he's done in the past. So in 2004, when the ICJ issued an advisory opinion
saying that we had no right to self-defense,
saying we had no right to self-defense, that wasn't the line that Barak took. Barak said that they were mistaken in their judgment, which is. I mean, it's obvious that they were mistaken in their judgment. I certainly respect Barak for having the intellectual honesty to say so, but he didn't go beyond that as far as I would go. What I would say is that the court had just demonstrated its own illegitimacy, that it was not acting as a court of law, that it was acting as a PR agent for anti-Israel forces in the General Assembly, and it was giving them, it was dressing up their prejudice with legal rhetoric. And I think that that's what happened then. What's happening now is the court is being asked to dress up the prejudice of the ANC and Hamas in legal rhetoric, and in part, that's what the court is going to do. And it's a mistake, therefore, to think that Barak is oriented towards pointing that out. That's not the way he that's not the way he analyzes these things, and it's not the way he acts. But there's more than that, right? I mean, part of when we're thinking about how do we blunt the use of these institutions against Israel, so part of it, as I said, is to try to delegitimize them, to make it so that it's clear what they are, and that's to say things like the court is on trial, not us, right? We will continue following international law no matter what this court does. Right. But if this court does what South Africa wants it to do, to come out against international law and against the Jews, the court is going to permanently lose in some of its legitimacy that in a way that it may never recover. But that's part of it. But there's another part, which is shaping our own rhetoric and shaping the way these institutions can interact with us. So one of the first things that we ought to have done years ago, and nobody seems to have suggested this, and I don't understand it, is to start withdrawing from jurisdictional clauses in treaties, and where it's not possible to withdraw from the jurisdictional clauses. They're called compromissory clauses, but that's the technical name.
Okay.
In places where we can't withdraw from them, to withdraw from the entire treaty. And that's what the United States did. The United States withdrew from the Vienna Convention on diplomatic relations, and then the Vienna Convention on consular relations. And one after the other, it dropped out of these treaties because it didn't want the ICJ to have legal authority claim jurisdiction. Now, in this case, there's no question that the court does have jurisdiction under the Genocide Convention. The question is just, is there any genuine dispute here of the Genocide Convention? And I think it's not the easiest thing in the world for Israel to argue no. It's not the easiest. It's because, on the one hand, the South African claim is completely specious. Of course Israel's not violating the Genocide Convention. Of course they don't even think so. They don't have a scintilla of evidence to indicate it, because it's all a fabrication, right, to sell an anti-Semitic narrative. On the other hand, Hamas most certainly did commit genocidal acts. Hamas certainly acted in a way that's under the Genocide Convention. Now, it's true that this is a little bit asymmetric, because our dispute over Hamas's genocidal act is not with South Africa. South Africa's crimes here are South Africa is materially supporting a terrorist organization. On the other hand, while South Africa has an abstract duty to prevent and punish genocide, they don't have any particular duty to do anything towards Hamas for that reason, right? Hamas's genocidal acts have to be punished ultimately by whoever gets their hands on them, meaning us, right? Not South Africa. So we don't really have a dispute, but at least there's this colorable South African argument because we're a party to the Genocide Convention, and what we should do is notify the Secretary General that we've withdrawn from Section 9, Article 9 of the Genocide Convention, and
which says what? Which gives the
ICJ jurisdiction. And if they say no, then we should withdraw from the Genocide Convention, right? If he refuses to accept withdrawal from Article 9 only, then we'll say we believe the Genocide Convention is customary law. We are, of course, going to continue following it to a T, except for Article 9, because we do not believe that the ICJ should have jurisdiction over any disputes, because it is a political institution and not a legal one, as we're about to see, right? And we should be going through, there are about 30 treaties like this with compromissory clauses. We should be withdrawing from every one of them, from the compromissory clauses, and if we can't, then from the treaties themselves. And this is just, the ABCs of being able to
fight lawfare.
Fight lawfare, to move the fights to institutions that are not stacked in advance against us. And the other thing that we have to be doing is where we have the ability to put out our narrative. It's not simply a narrative of we didn't do this thing, you did bad, we did good. It's also a question of shaping the understanding of international law. And so here, too, we're making another mistake. So you have the foreign ministry is going around saying, how can you say that we committed genocide? We are permitting and even encouraging humanitarian aid to Gaza.
And also, it's not just that. The whole Israeli strategy for fending off this allegation seems to be to undermine our own war effort or our options going forward. So Prime Minister Netanyahu clearly, speaking to the ICJ ahead of Thursday's opening hearing of the South African claim, said Israel has no intention to control Gaza, and we don't support the depopulation of Gaza, or however it was that he phrased it precisely. And I thought, I don't know, 80% of Israelis do, including very senior members of your cabinet, including members of the opposition. And, if the Gazans want to leave right now, The Guardian reported last week, The Guardian, which is not a pro-Israel paper by any stretch of the imagination, that Gazans are paying intermediaries $10,000 to try to get on the lists that the Egyptian ministry is the Egyptian defense ministry or military is putting out of the Gazans allowed to cross out of Gaza into Egypt. So they're paying $10,000 apiece to try to get out by bribing Hamas, by bribing Egypt to get out. And here, in order to fend off a fake genocide claim, Israel is saying, yeah, they should all be forced to stay here when Israelis want them to leave and they want to go.
I look, it may. What's the best reaction to?
And then we don't want to occupy. Like, what does that even mean?
Whatever the policy should be towards voluntary emigration or towards future political arrangements, that's not the question. The question is, should Israel be locking itself in, denying itself options in order to abide by a legal standard that is applied to no one else? And the answer is, of course, Israel should not be doing that. Israel shouldn't be saying, well, we're not committing genocide because we're giving humanitarian aid. Israel's under no obligation to give anything to the Gaza Strip as long as it's controlled by Hamas. Israel has the right to block everything going into the Gaza Strip.
So that's actually interesting. Everybody's been saying that under international law, Israel is required to feed and clothe and give free medical assistance and fuel to the Gaza Strip. What is that?
And this is part of what we see over the years, this development of a different set of international laws that apply only to the Jewish state. The international legal apartheid that's supported by South Africa. It's been supported by the ANC since way back when. And we shouldn't be cooperating with that. We should be trying to rip it apart. We should be abiding by the same international law as the law that applies to everybody else. Not that everybody else follows, because it's absolutely certain that no matter what happens, South Africa will continue violating the law by materially supporting terrorist organizations. It's clear that no matter what happens, Iran will continue to support genocidal organizations. Right? It's all these things are clear. So we're not saying we don't have to demand that that we won't follow international law until everybody else follows it, because we know they won't. And we, for whatever reason, have decided that it's our policy and it's our interest to follow international law. But it's definitely not our interest to allow the creation of this parallel adverse standard of international law, specifically for the Jewish state.
Why do we do that?
We're feeding into it. And
why would we do this? Why are we doing this? Why are we playing this game? Why are we being a sucker all the time?
I think this is because primarily there is no strategic thinking about this at all in the legal advisors' offices and the foreign ministry. They're thinking about this defensively. How do we rebut the charges that they've made against us? And that's not the question we should be asking. No. The question, it's not how do we fend this off? How do we whack this mole? The question is, how do we fight long term in order to win on the lawfare battlegrounds? And that means that we have to be promoting a different understanding. We have to be promoting a uniform understanding of international law that goes no farther than it actually does right now, and one in which the institutions, the politicized institutions, which is all the institutions we've got today, in which the institutions are weaker or even eliminated. It's not clear to me that there's any more use for the ICJ than there is for the League of Nations. Right? The League of Nations was a failure, and it went by the wayside. And I don't see that the ICJ does anything particularly useful that we ought to be fighting to maintain it. Let them fight to prove that they have some use in the modern world, that they actually promote international law rather than the political agendas of the world's worst actors.
Right. Who are judges on the panel.
Yeah, it's the way the election system is set up for judges and the ICJ is more or less the way all General Assembly elections go. You have 5 judges that are match the 5 permanent seats of the Security Council, and then you have another 10 judges, 2 each from each of the regional groupings. There has never been a full-time Israeli judge, and until the system is changed, there never will be.
Because we're not a member of the
We're a junior member of the Western European and other group, subject to a few restrictions, not the restrictions we used to be, but over the years we were not permitted into anybody's group. And then when we were permitted into a group under a large number of limitations that the French insisted on, because they weren't going to allow us into their club, as if we were proper civilized human beings, when after all we're just Jews. And then we get to today, where there's relatively few, but still you have an entire history in which we were unable to be elected. And now we have a situation in which we're just simply subject to the political prejudice.
We're unlikely to be. We're unlikely to be.
It won't, right. Technically it's possible, but it'll never happen.
Right. So, so moving forward, what you're essentially saying is fight fire with fire. Whatever the interim order that they're going to put out against Israel was going to be, just ignore it. And in the meantime, that the goal of Israel in this arena, having requited ourselves well or whatever on Friday in our jurist statements there, that the whole goal of Israeli policy, insofar as the ICJ is concerned, is to just delegitimize the proceedings.
It's 2 things. It's
and the court itself.
It's to weaken the institution as much as possible, but it's also to sell a different version of international law. Their utilization of the ICJ is designed to sell the apartheid version of international law, where Jews get permanently inferior treatment, permanent double standards against the Jews. Right. And our goal should be to at least create the material for those people of good faith out there. And there are such people. Not all the world is anti-Semitic. There are some people out there who like Jews, and there's some people who may be indifferent but have a sense of basic elementary fairness and equality. Yes, and we have to give them the material to be able to fight, right? So we have to be able to promote a different understanding of international law. And we're not doing that. We're giving, when you get up in court in a ridiculous proceeding like this, and we say that we're not guilty of genocide, right? We're not giving anybody usable material for international law. We're treating an absurdity as if it's a real legal argument to be rebutted. Now, I'm not saying we shouldn't be doing that. I'm just saying that that's
not the only thing that we should be doing.
We have to be doing well beyond that.
So let me just ask you one final question, which is, I mean, over the years, I've understood the importance of making the argument that Israel's fight is the world's fight, and in a very serious way, what's happening here with Israel vis-a-vis Iran and its proxies is very much the world's fight. But nobody seems to care, And so then I wonder about whether it's even worth belaboring a point that people simply don't care about, because if they're willing to cater to Iran and to Hamas, then they're just willing to piss away their own national security as well. But here, I think, there are consequences for America, for Britain, and for other states, for India. I mean, for any state that's fighting a war to defend itself against threats to its national security, when the threat is a party that has a large group of other countries that stand with them against whatever nation's being targeted. So it's not just us. I mean, as you said, the United States is being targeted there. I think that Britain has also been targeted there. And so, the question is, what's at stake for them in this kangaroo courtroom against the Jewish state?
There's, for different groups, different things, right? So there are those who very much want these institutions to succeed. They think there's something good to come out of
the Aaron Baraks of America.
Yeah,
the Biden administration.
There's something good to come out of the ICJ. There's something good to come out of the UN, and if we can fix them, they can do that. Right? Now, I don't share this optimism, but if you are of that school, then there's something really, really important to do here, which is you have to make it clear to the ICJ that along this path, that this path leads to death of the institution. The institution cannot continue this way. Right? The Clinton administration back in the day squeezed the UN a little bit on anti-Semitism, and it didn't say it was doing this for the Jews. It was doing this for the UN. And it got some very minor reforms that ended up being not good enough. But there is a group out there that's institutionalist, that believes these institutions have value, and they need to join this fight to force the institutions to do bigger reforms than the UN did back in the day, to really reform so they're useful. That's number one. Number two is the Iran and its proxies and Iran's alliance structure with China and Russia to do ill in the world is an international, transnational threat. And it's not simply in the Middle East, where they've successfully destabilized half the Middle East. You can see right now they're attacking central international shipping lanes.
Right.
They're engaging in acts of piracy. They've also engaged in transnational terrorism against others.
They're engaging in acts of international piracy with cruise missiles. I mean, this is not.
Well, this is not a small thing. But I also think you have to think about things like Salman Rushdie. Salman Rushdie is giving a speech, halfway around the world,
and he gets
stabbed, right? Yeah. This is not a small threat. This is a large threat, and these countries have to act. That said, there's a reason why we get stuck with this, which is the Iranians want to kill us first.
Right.
And I will also say that we will find it very difficult to find allies unless we take up the fight ourselves. That is, it's going to be very hard to find people. For example, it's Hamas. Okay, it's going to be very hard to find Americans who are pro-Israel, who are willing to go farther in being anti-Hamas than we are. Right? It's going to be hard to find people in the United States, even if they're well disposed towards Israel, to be more anti-PLO than Israel is. So when Israel stopped being anti-PLO, when it started just accepting the PLO's abuse of Israel in the world, then it became impossible for almost any ally of Israel in the world
to stand up
against the PLO. And so there are international fights here, but so long as we're the number one target, we have little choice but to take the lead.
I see. All right. Well, I think that we're going to leave it there for now. I think that we covered a lot of ground. Look, this is we're just getting it from all sides, and of course we are, right? Because because our enemies actually do seek to annihilate us, so they're fighting a full spectrum war, both politically, legally, economically, with the shipping, and militarily with Lebanon and with Gaza. And we just have to recognize it as such and fight as such. I hope very much that the people who are supposed to be thinking about this in a serious and strategic way are watching us today. I thank you guys for watching us today. And make sure that you pass this information around, because the more people who watch it, the more impact it has on the people who are making bad decisions, and maybe they'll make good ones. And I want to thank you very much, Professor Avi Bell, for coming to the studio today to share this with me. And keep up your important work. It's critical. Thank you very much.
Thank you.